Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the world of international taxation. For this, we have selected three important cases. The first one discusses the treatment of free brand ambassadorship service in pursuance of share purchase agreement with foreign entity as deemed international transaction. The second one discusses the taxability of premium paid by Indian insurance companies to foreign reinsurance companies. And the third one discusses the treatment of services provided by foreign entity post completion of installation activities in India as installation PE. Our first case is related to a famous Bollywood celebrity, Shilpa Shetty, and the dispute revolves around treatment of a brand ambassadorship agreement deemed international transaction. The problem started when Assessee entered into a share purchase agreement whereby certain shares of Mauritius-based company stood transferred to another company incorporated in Bahamas, which was represented by her husband, Mr. Raj Kundra. The Assessee herself was neither a buyer nor a seller of shares under the SPA. However, she undertook to provide brand ambassadorship services to Jaipur IPL Cricket Private Limited, which was a wholly owned subsidiary of EMSHL, in relation to promotional activities of Rajasthan Royals, an IPL cricket team owned by GICPL. The SPA was provided that such services were to be provided by the Assessee completely without any fees. Let's understand what exactly happened in this case.
The department observed the Assessee and EMSHL as an associated enterprises and held that the service rendered by the Assessee to JICPL by virtue of share purchase agreement constituted an international transaction. Thus, relying on the contemporaneous brand ambassadorship agreement of Assessee, an amount of Rs 3.42 crore was determined as ALP in respect of service provided by her, free of charge to JICPL. This finding of department was confirmed in appeal on the ground that the Assessee and Cookie were A's in the view of section 92A, and the Cookie company was benefited in terms of share purchase consideration to the extent of monetary value of brand promotion services provided by Assessee to EMSHL.
Now let's see what the appellate tribunal finally decided. Profession of an individual cannot be separated from himself to consider as an enterprise under section 92F, since the term profession is independent from an individual and hence is not a person within the meaning of section 231. Section 92A deems two enterprise as AE only if one of the enterprise is controlled by an individual and the other enterprise is controlled by such individual or his relative. Existence of prior agreement is a precondition to held a transaction between AEs and non-AEs of an Assessee as a deemed international transaction. Section 92 is not an independent charging section to bring in a new head of income or to charge tax on income which is otherwise not chargeable under the Act. Now let's move on to our second case, where Indian insurance company was made liable to deduct tax at source while making payment of premium to non-resident reinsurance companies. The Assessee company in the present case is engaged in the business of general insurance in India, recognized as such by IRDA. However, when an aircraft or satellite was insured, the Assessee had to assume large amount of risk which the Assessee might not be able to handle by itself. Therefore, in order to distribute the risk, the Assessee entered into a reinsurance contract with a non-resident reinsurance company. Let's understand what exactly happened in this case.
During the course of assessment, it was pointed out by the Assessee that foreign reinsurance company deals only with the Indian insurance either directly or through independent brokers situated either in India or outside India. Further, the brokers acted only as facilitator between Assessee insurance company and non-resident reinsurance company. Therefore, the Assessee urged that since the non-resident reinsurance company operates outside the India, their income was not chargeable to tax in India, and therefore the Assessee was not liable to deduct taxes on the premium paid to those non-resident insurers. Rejecting these contentions, the AO carried out disallowances under Section 40A for failure of assessee withhold TDS on the premium paid overseas.
Now let's see what the appellate tribunal finally decided. The premium paid by Indian insurance company to non-resident reinsurance companies are not allowable as deduction. Rather, they attract withholding tax liability.
Here are the key takeaways. IRDA is not authorized to frame any regulation contrary to the provision of Insurance Act. An Indian insurance company is not free to contract for any reinsurance over and above the statutory ceding prescribed by IRDA with non-resident insurer. The term other insurer as provided under Section 101A of Insurance Act 1938 is only the insurer which was defined under Section 2 of Insurance Act. Therefore, the Indian insurer cannot have any reinsurance agreement with non-resident reinsurance company other than insurer under Section 2 of Insurance Act. When it is made sine qua non for the non-resident reinsurance company to establish branch office in India after financial year 2014 for the purpose of conducting business in India, then naturally the profit of non-resident reinsurance company will be taxable in India.
Now let's move on to our last case where an international famous food joint was brought within the corner of Indian tax regime. Let's understand what exactly happened in this case. The Assessee is an Indian subsidiary of foreign counterpart engaged in a specialized market for traffic control, navigation and port management system. It has been awarded a contract by ONGC for supply, installation, testing and commissioning of vessel and air traffic management system along with the provision of maintenance services. The contract envisaged a provision of annual maintenance services for 6 years post-warranty period. However, the activity of rendering maintenance services were later on subcontracted to a local independent contractor. Now, AMC fee charged in relation to rendering of annual maintenance services was treated by the department as business profit attributable to Assessee as an installation PE in India.
Now let's see what Income Tax Appellate Tribunal had finally decided. No attribution of profit can be made in hands of non-resident entity based on receipt from offshore supply of equipment in absence of its PE in India. Presence of an Indian contractor to which foreign entity has subcontracted whole AMC work on principal-to-principal basis does not create any virtual presence of said foreign entity in India. AMC services provided post completion of installation activities at the site of customer cannot lead to carrying out of installation activities for the purpose of constitution of an installation PE in India.
With this, we wrap up this episode of Legal Wrangle. Next time, we will bring some more interesting cases from the world of taxation. Keep watching TIOL Tube. Thanks for watching.